Yesterday, a case against H-4 EAD was dismissed in Washington, D.C. A coalition called SaveJobs USA had filed a lawsuit initially in 2015. They've been going at it for the past 8 years. That case was declined because the court said, look, you have no standing, you can't sue. They took it in appeal. The appeal was granted. They came back and they made their arguments in a summary judgment motion, which was resisted by the defendants, which includes the USCIS. So basically, this case was dismissed by the court, and the court said, you have no ground to stand on. USCIS has acted properly. They have the authority to promulgate the H-4 EAD program. This program is not illegal. There were many arguments advanced by the SaveJobs USA people who are trying to cancel the H-4 EAD program. The first argument was that, Congress never gave Department of Homeland Security the authority to allow foreign nationals like H-4 visa holders to work during their stay. And the court said the statute is quite clear. The Attorney General, in this case Department of Homeland Security, can prescribe the conditions and the time for admission of people as non-immigrants in the United States. There's clear authority. There is no question about it. And in fact, programs like F1 OPT have existed since 1947. So this argument is absolute nonsense. And then the court pointed out that Congress had allowed this program to exist. There was no question. They announced, then the defendants, the plaintiffs, the SaveJobs people, advanced another argument. They said that, this is like making laws and only Congress can make laws. And the court said, no, that argument too is nonsense. They said, the H-4 rule was, this is again SaveJobs USA, that the rule was promulgated without explanation and without taking into account the effect it has on the labor market, etc. And the court said, even if we have every H-4 spouse apply for an EAD in the first year, where there's probably the most eligible H-4 spouses because the program is just coming into picture, that year, it would amount to less than 0.12% of the US workforce if everybody applied in the same year. Now, of course, there is considerable dilution. So all things considered, the court said, you have no case, this case is dismissed. Now, can they appeal? Sure, they can appeal. What is likely to happen? Just going by the stand DC Circuit has taken on this case and issues presented in this case, almost certainly I think they will lose in appeal.